want to thank you for joining us as we open a new season of Sprout HR plus Finance Experts by Sprout Solutions. Now, before I start, I just want to ask you a timely question. How are you? I'm sure this is a critical time for HR. And so, with that in mind, we're here to give you legal and practical advice to help lead your company. By the way, just so you know, we're also live on Facebook. You might want to invite your friends and colleagues to watch us on Facebook. Now, allow me to give you a brief introduction to who we are. Sprout is an HR technology company that helps your company take it to the next level in terms of taking care of your people. We provide systems and support for numerous things like recruitment, timekeeping, payroll, analytics, all in a cloud-based system to enable work from home for you. And now, we hope to be able to help you lift up your team during this crisis. All right, next slide, please. Okay, so while we're waiting for everyone to tune in, I'd like to introduce you the raffle mechanics. So we'll be having a raffle for this session. Now, here's how you can join the raffle. Collect all 3 keywords and get a chance to win a 500 peso Shopee gift certificate. All right. So first, you have to collect all 3 keywords, and those keywords will be flashed on the screen throughout the seminar. Number 2, you have to follow our official Facebook page at Sprout Solutions PH, and then comment all 3 keywords on the post pinned on our page or on the post containing this video. And we'll be announcing the lucky winner at the end of the session. And we'll be sending the Shopee GC code through email after the session before 6 p.m. So I hope you took note of that. So join our raffle, collect all the 3 keywords, and get a chance to win 500 peso Shopee gift certificate. All right, so next slide, please. Okay, so we have our first raffle keyword number 1. So I hope you're taking note of this. I hope your eyes are fixed on the screen. Our first raffle keyword is labor. So I hope you got that. Our first raffle keyword is labor. Also, I just want to announce that we will have a Q&A portion after the presentation. So please prepare questions for the fireside chat session later and ask us anything on your mind with regards to matters concerning our topic for today, which is business unusual, best practices on employee disciplinary policies. Now, without further ado, I'd like to announce our speaker for today. He is Sprout's Legal Counsel and Public Sector Engagement Lead and a fellow of the Arellano University School of Law, Center for Legal Education and Research. So let's all welcome Attorney Lester Ople. Attorney?
Hi, good morning, everyone. I hope you're all safe and healthy. So we have a typhoon about to arrive in the Philippines. So I hope aside from the ECQ or GCQ or modified ECQ requirements or rules, everyone who is attending this webinar as well as their families and colleagues are safe. So again, welcome to today's episode of Sprout's webinar series. So thank you for joining us. We have been here for, I think this is our 11th episode. So thank you for joining us and spending your valuable time with us every Tuesday and Thursday. Okay, so let's get to it. Next slide, please. Okay, this is a reminder from the Supreme Court regarding how the laws and the legal system views employee termination disputes. And if you have been a seasoned HR practitioner, you would definitely have your share of employee termination disputes. And you are aware that generally the moment that a dispute reaches the courts, the employer is on a disadvantage because the legal system will view the legal requirements very strictly in favor of the employee and interpreted strictly against the employer. But that does not mean to say that in every labor dispute, the employee would win. It simply means that the employer has a very high standard to comply with for the legality of the termination to be upheld. And this has been held by the Supreme Court in a very, very long line of cases. And the reason for that is that one of our presidents, former President Magsaysay, said before that those who have less in life should have more in law. And our legal system is stacked in favor of the laborer, in favor of the employees, simply because the economic and legal system of the country has more, the employees are generally viewed as having less power in terms of negotiation, because the employee is viewed as somebody who depends on the employer for sustenance. And that is why in cases of disputes, the courts will side with the employee. Okay, next slide, please. Next slide, please. So a termination discussion is always a very difficult conversation. I will line this up with maybe a breakup with a significant other in terms of the emotionality associated with it. But let us be reminded that employee discipline is management prerogative and generally not subject to judicial interference. However, the right of an employer to terminate is only justified if it is dictated by legitimate business reasons and is not oppressive. The legitimate business reasons for terminating an employee will be discussed in detail as we go through the presentation. Next slide, please. So before we go into the details of employee termination, the requirements of being able to exercise this management prerogative, I would like to remind everyone of the existence of Labor Advisory number 1-2020. This is a fairly recent issuance of the Department of Labor, and this was issued way back in January. If you remember, that was the time when Taal volcano erupted, and the resulting eruption of Taal resulted in ashfall experienced in large parts of the NCR, and as a result, people were hesitant in reporting to work because of the safety and health issues that are associated with ashfall. So it is very timely at that point that the DOLE issued advisory number 1, which is in compliance with the Occupational Safety and Health Law. Advisory number 1 states that employers may suspend work to ensure safety and health of employees during natural and man-made calamities, and that those employees who fail or refuse to work by reason of the imminent danger situation because of the natural or man-made calamity shall not be exposed to nor subject to any administrative sanction. Next slide, please. So what does this advisory mean for us as employers? The question here is the threat of COVID-19 infection considered an imminent threat sufficient for advisory number 1 to be applicable? And is an employer left without recourse in the event of refusal to report to work? This is something that the present issuances of the Department of Labor do not yet clearly state if COVID-19 is an imminent threat. But we hope that with the presentation today, we will be able to guide our attendees with respect to what would be the thought process that has to go into that would have to go into a discussion about terminating an employee for the causes that we will be discussing further in this presentation. Okay, next slide, please. Okay, a reminder for those employers who have applied for and qualified for the small business wage subsidy, please note that one of the requirements of the SPWS is that the business must commit to maintaining the employment status of eligible employee beneficiaries before the ECQ and throughout the SPWS period. This means that employees cannot resign during the ECQ period, and that, again, non-compliance with this condition will result in the employer having or being required to refund to the government the subsidy amount. And that is 8,000 pesos for NCR for a period of, for 1 month for a period of 2 months. So that's a total of 16,000 pesos. Next slide, please. One question here is that will the grant of the SBWS benefit, is it construed as a restriction on the right of an employer to impose disciplinary action, including termination? Does this mean that for a probationary employee who fails to qualify for regular employment, does it mean that the employer is no longer allowed to non-regularize and therefore avoid the penalty of having to refund the small business wage subsidy amount? This is a question that we don't have an answer yet because the relevant issuances of the SBWS and the Department of Labor are still silent with respect to how the SBWS affects management prerogative. But again, as we go through this presentation, I wish to impart on our attendees that there's a certain thought process that has to go into getting into the discussion of whether or not to terminate an employee. Okay, next slide, please. So briefly, these are the grounds for company-initiated termination of employment. The first one definitely is a termination of a probationary employee, which there are two reasons for a probationary employee to be dismissed from employment. Number one is, of course, the just cause termination. And when the probationary employee fails to qualify as a regular employee in accordance with the reasonable standards made known by the employer to the employee at the time of his engagement, we also have the just causes of termination, the grounds of which are specifically stated in Article 282 of the Labor Code, and of course, authorized causes, which are enumerated in Article 283 and 284 of the Labor Code. Let's go into this detail now. Next slide, please. Okay, so if you have been attending this webinar series, you're aware that in a previous episode, we have discussed other options in the right sizing toolkit. Now, why am I showing this slide again? This is because I want to impart a particular thought into our attendees today, which is employee discipline should not be used as a means to manage cost on the labor side. Meaning, hindi po dapat na isipin natin na let's terminate an employee because we need to manage labor cost. It should be somebody committed the grounds allowed under the law for termination of employment for just causes or authorized causes, which we have also discussed in a previous episode. But if your reason for thinking of terminating employees is only to manage cost, then these are the options available to you. Number one, temporary closure or floating status. Number two, reduction of hours or days worked. Number three, rotation of employees. Number four, forced leave. These options were discussed in a previous episode, so please visit the sprout.ph website COVID resources page so that you can access the PowerPoint as well as the recording of that particular webinar. So we will only discuss this in passing. Next slide, please. Yeah. Next slide, please. Okay. Additionally, there are other management prerogatives that may be exercised, again, to manage cost. Retirement is also another option, redeployment or transfer of personnel, as well as retooling or change in the job tasks of personnel. These are options that are available to all employers if your objective is to manage costs. So again, I want to impart that if your objective as an organization, this has to be if your objective is to merely manage costs, then do not think of termination of employment as your option. Think of other options which we have discussed here, and the details of which are provided in the previous webinar, as well as the materials all available on the Sprout COVID resource website. Okay, next slide, please. Okay, we are now on the second raffle keyword. The second raffle keyword is discipline. Next slide, please. Okay, now we go to the just causes of termination of employment. Next slide, please. Before we go into the substantive matters of termination of employment, I want to share this case decided by the Supreme Court in 2007. The case is called King of Kings Transport versus Mamak. And a very brief version of this case is that a conductor was found to have discrepancies in the tickets issued as well as the collections from the bus fare. That particular conductor was made to explain why the discrepancy happened, and after the conductor provided an explanation, the conductor was terminated from employment for a just cause of termination as provided under the labor code. And the Supreme Court took that opportunity to explain the requirements to be satisfied by all employers whenever a termination of employment has to be completed, which is, number one, a written notice must be served to the employee, which states the grounds for termination and gives the said employee a reasonable opportunity within which to explain his side. Second, a hearing or a conference during which the employee, with the assistance of counsel if so desired, is given a meaningful opportunity to respond to the charges, to the allegations. And third, a written notice of termination served on the employee, stating that upon due consideration of all the circumstances, the evidence presented, the explanations offered, the company has arrived at a conclusion sufficient to justify termination. And in case of termination, the said notices shall be served on the employee's last known address. This is what we call the twin notice rule. And again, the case is called King of Kings Transport versus Mamak. If you have spare time, please take the opportunity to read through this particular case. This is available for free on the Supreme Court website, as well as on Lawfil, which is a website managed by the Arellano University for public consumption. Okay, next slide, please. Now we talk about further details on the first notice requirement. So when you talk about the first notice should state the specific cause or grounds for termination as provided for in the labor code. We will discuss the grounds later. Second would be a detailed narration of the facts and circumstances or the allegations against the employee. A general description is not applicable. And then a directive that the employee should be given an opportunity to submit a written explanation within a reasonable period. And the Supreme Court actually mentioned that the reasonable period should be construed as at least 5 calendar days from receipt of notice. Please note that the 5 calendar days requirement is a minimum requirement as explained by the Supreme Court in the King of Kings Transport case. So how does this go? So a general description, a specific cause or ground for termination. You would have to cite the specific ground as stated in the labor code. So there are 5 grounds stated in the labor code. So you're supposed to say that. Number 2 would be a detailed narration. It cannot be a general description. So a general description would say something like, on one of the audits done in your cash, in your petty cash in your possession, you have been found to have a discrepancy. You are required to explain within 5 days why you should not be disciplined for this particular act. That's a general description. So a specific description would be something along the lines of, on March 1, you were assigned as a petty cash officer with custody of 5,000 pesos as petty cash for office operations. During a petty cash spot audit conducted last April 2, you were found to have a discrepancy of 4,000 pesos, and you are unable to present supporting receipts or invoices to support the lack of petty cash available in your possession. You were given time of 24 hours within which to provide supporting documents for the missing petty cash, which you are unable to do so. You are thus being required to explain within 5 days why you should not be disciplined for the possible offense of theft. So this is what we call a specific description. There are dates, there are facts, there are references to previous acts and specific acts of the company and the employee. So hindi pwedeng sinabi mo lang na pinagbibintangan ka namin ng pagnanakaw, period. Hindi siya pwede. It has to be sa ganitong date na nagkaroon ng audit. During the audit, you were found to have a discrepancy. This discrepancy, you were given a period of 24 hours to correct the discrepancy. And despite the 24 hours being completed, you are still unable to explain sufficiently why you have the discrepancy. You are thus required to explain why you should not be disciplined for a possible case of theft. That's it. Okay. Regarding the hearing, so it depends on your company policy. If your company policy or code of conduct specifically requires a hearing type of meeting after the notice has been issued, then you are required to observe that, because the policies that you have set forth for the company should bind you and the employee. So if your policy is silent, then it simply means that you go with what the legal requirements are, what the minimum legal requirements are. And that is a formal hearing is mandatory only when requested by the employee, or if there are specific evidentiary disputes that has to be addressed. And the best way to address those would be a hearing type of activity. Okay. You may have somebody post a question, who should be imposing this first notice requirement? Again, it depends on company policy. If your company policy states that it must be HR who issues the first notice, then it should be HR. What is important is that if you have a company policy as to how discipline is imposed, then you are required to adhere to it. Otherwise, you run the risk of legal risk in not complying with the policies that you have set forth for your company. Okay, let's go to the next slide. Now let's talk about the second notice requirement. So after the first notice, you have required the employee to explain, and then the employee is furnished an explanation, or you have conducted the administrative hearing. The second notice would state the conclusion of the investigation and the proceedings that the employer has conducted. What does this mean? That the notice should state the following. Number one, that there are circumstances that have been considered by the employer in arriving at the decision. Number two, that grounds have been established to justify the severance of employment. And I would like to add the third one, which would be the effective date. No? So some companies do it effective immediately. Some companies, do it. They give a transition or a grace period, or what we call a graceful exit option. So again, it depends on your company policy. Okay, so there are two options in serving the first and the second notice. It should be either personally served or served via the employee's last known address. Okay, let's go to the next slide. So previously we talked about one aspect, which is called the procedural aspect of terminating employment. We talked about the first notice, which should state clearly what grounds have been found that the company will be invoking pertaining to the discipline. The employee has been given ample time to explain himself and defend himself, and that circumstances have been established after all the proceedings have been considered. Circumstances have been established, and a conclusion has been arrived at that gives you either a decision to terminate or not terminate, or impose a penalty lower than termination to the employee. Now let's talk about what we call the substantive aspect of it. Ano yung talagang requirements for termination? So Article 282 of the Labor Code, before I get into this pala, no, you would notice that I refer to Article 282 and not 296. Because I refer to the Labor Code in its original state rather than the amended state, no? And for purpose of clarity, I still prefer to use the old numbering rather than the new numbering, because the new numbering is confusing, no? There have been piecemeal amendments to the Labor Code, since its inception. It has been since 1970, since 1970s pa yung labor code. So there have been various amendments, piecemeal amendments, and I personally think that it has to be recodified and renumbered. Total uso na rin naman yung nag-revise tayo ng ating mga laws. So I am hopeful that the lawmakers will be amending it soon. Okay, let's go back to the grounds of termination. So the first ground of termination provided for in Article 282, it's called serious misconduct. What are the elements for misconduct to be serious? Number one, there must be definitely misconduct. Hindi pwedeng haka-haka lang, hindi pwedeng chismis lang. It has to be a clear act of misconduct. And second element, it has to be of a grave and aggravated character. Third, it must be related to the performance of the duty of the employee. And that lastly, and most importantly, there has to be a showing that the employee has become unfit to continue working for the employer. Okay? What about willful disobedience or insubordination? The elements of willful disobedience or insubordination are that there must be disobedience or insubordination. It must be willful and intentional, characterized by wrongful and perverse attitude. The order violated must be reasonable, lawful, and made known to the employee, and that the order must pertain to the duties which employee is engaged to discharge. So, ano yung disobedience or insubordination contemplated ng batas? It is not merely the non-compliance of a lawful order of a superior. No? It has to be a very grave and aggravated disobedience or insubordination characterized by wrongful or perverse attitude. What would be an example here? For example, you are in a manufacturing environment and the particular orders pertain to safety and health during the manufacturing process because you are working with hazardous machineries. So if the order would be wear your safety hat or hard hat and safety shoes at all times in the production floor, and somebody enters the production floor not wearing the proper protective equipment, and it causes somebody to, or there is a tendency for that particular act to cause additional harm to co-workers. And the reason is not because the employee merely forgot, it's because the employee really does not want to comply. That is the wrongful and perverse attitude. But if there are legal justifications by the employee, for example, like what I mentioned earlier in Labor Advisory 1-2020, it may not necessarily be called willful disobedience or insubordination. So this will be a pickle, lalo pa ngayon that we are in modified ECQ. No? What I am thinking here is that most companies who have returned to work and have identified particular personnel to return to work, and such personnel refuse to go to work, maaari ba natin gamitin itong willful disobedience or insubordination na to? In light of Labor Advisory 1-2020, I say proceed with caution. No? Why? Because an employee is not allowed to be exposed administratively for sanctions arising out of refusal to report for work due to unsafe working conditions. Okay, let's go to the next slide. Gross and habitual neglect of duty. This is a very simple ground of termination because there are only two elements, but please note that it is gross and habitual neglect, not gross or habitual neglect. The difference is very important because a simple gross neglect of duty, if it's a single instance, may not necessarily be sufficient as a ground for termination. But if the habitual neglect of duty is gross in character or vice versa, that may be sufficient for an employer to terminate an employee based on gross and habitual neglect of duty. This typically happens to people who are placed on PIP, performance improvement plans. But what is important in a PIP is that there is documentation that the negligence is gross and habitual in character. Next, we talk about fraud. This one is another broad element for, or rather broad ground invoked for disciplinary processes. The elements are as follows. There must be an act, omission, or concealment. And this act, omission, or concealment involves a breach of legal duty, trust, or confidence reposed by the employer, and the fraud is committed against the employer or his representative, and it is in connection with the employee's work. So what are examples of fraudulent activities? One would be the malicious concealment of previous conviction. No? So for example, in certain companies, you would have a pre-employment form, an application form, and one of the questions there, this is particular for government, no? One of the questions there is, have you been convicted for a crime involving moral turpitude? And if the employee fraudulently conceals that there has been a previous conviction, that may be a ground for termination. What else are fraudulent grounds? For example, an employee was issued a corporate credit card, and the corporate credit card has a particular rule or set of rules governing the use. It has to be for a particular business expense. It has to be, there's a certain processes or justifications that has to be complied with before the company credit card is used. And the employee uses that particular credit card, corporate credit card, for personal expenses that are not in any way related to corporate expenses. Bumili ng sneakers, bumili ng skin sa Mobile Legends. You know, things like that may be considered fraudulent grounds because you ask them to explain, they are required to reimburse, but it was the employee attempted to pass it off as a legitimate business expense. Ayun, fraudulent activities na yon, and it may be sufficient to cause termination of employment. Okay, let's go to the next slide. Okay, loss of confidence. Loss of confidence, there must be an act, omission, or concealment. The particular act, omission, or concealment justifies the loss of trust and confidence. And this is very important. The employee must be holding a position of trust and confidence. And the loss of trust and confidence is not simulated, and it must be genuine and not merely an afterthought. So, ano yung positions of trust and confidence? These would be positions that have a particular, there are particular acts by the employer showing that the employee holds a position of confidence. Ano ito? Number one, cashier. Number two, mga taong na-issuehan ng corporate credit card. Number three, yung mga may fleet card. No? So these are evidence that you have loss of, or rather these are acts of an employer that show that there is a particular level of trust and confidence in the employee. Ano pa? One more substantial issue here in the loss of confidence is that if the employee is rank and file and not holding a position fiduciary in character, meaning hindi siya nag-hold ng company possessions or company cash or company resources in a fiduciary or trustee capacity, hindi siya pwedeng gamitan ng ground na ito. Meaning, ang isang bagger sa supermarket, there is no such thing as confidence or trust or confidence in that position. Pero ang cashier sa isang supermarket, dahil meron siyang possession and control of company resources, which is the cash, from purchases, it is a position of trust and confidence because of the fiduciary nature of the duty. No? So I want to emphasize that. So if the position is not one of trust and confidence, do not ever use this ground. Management rank employees, they are ones with trust and confidence, automatic yun. The moment that a manager, managers of a higher rank are generally in positions of trust and confidence. So your HR manager would be in a position of trust and confidence. Your chief financial officer, who is not a member of the board of directors, would be holding a position of confidence. No? So these are positions where you can invoke this ground. Again, please do not use this ground of termination of employment for a person who is not holding a position of trust and confidence. Okay, let's go to the next ground. It's commission of a crime. Very simple no commission of a crime. If an employee committed an act or omission punishable or prohibited by law, and the act or omission was committed by the employee against the employer, an immediate member of the employer's family, or an employer's representative. So, ano yung example nito? So, I'll attempt a slightly political example. Somebody was caught in possession of dangerous drugs prohibited under Republic Act 9165. Meron siyang 2 joint ng marijuana. Pero the person holds a rank and file position, and the arrest was made outside the company premises or in the household of the person. Is it commission of a crime contemplated under the labor code? My answer is no. Why? Because there is no the act or omission was not committed by the employee against the employer. So it is merely a crime committed by the employee, and the reason why you may be able to terminate him or her would be violation of a company policy, which we will discuss in a later slide. Okay. But what would be a commission of a crime against the employer? A commission of a crime against the employer would be, it's a company outing. Everyone was drinking, and then yung manager at saka yung supervisor nagkalasingan, nagkalabasan na sama ng loob, yung rank and file nagalit doon sa manager, binasag yung bote ng beer sa ulo ng manager. Is it commission of a crime? Yes, because that may be construed as serious physical injuries. Is it committed against the employer or the employer's representative? Yes, kasi the employee committed it against the manager. So that is commission of a crime. Okay, so let's go on to the next slide. This one is the most broad ground for termination of employment. This one is called analogous causes. The sticky thing about analogous causes is that, so we have the previous grounds discussed earlier, but if it's not among the grounds, then it has to be an analogous cause. But for an analogous cause to be considered as such, it has to be expressly and explicitly stated in the company rules, regulations, or policies. Ano yung example ng analogous causes? I would, in some industries like the pharmaceutical industry, there are some policies that prohibit dating relationships between people in various departments. Sometimes these pharmaceutical companies even prohibit dating with a competitor. So ito yung mga medrep. So if a medrep is able to enter into a romantic relationship with another medrep of another competitor, generally it becomes a cause for somebody out of delicadeza. The medrep would be resigning or requesting for a transfer. But in some cases, it may be considered a ground for termination of employment. That's the case of Glaxo, Detailman version. It's another Supreme Court case. Exactly what the Supreme Court discussed there was the prohibition to enter into a marriage. Ano pa yung analogous causes? Some of the analogous causes are actually another analogous causes rather is if you have a bargaining unit, if you have a union in your company, and there is what we call a union security clause, that would be an analogous cause for termination. So if the employer commits an acts that are prohibited by the rules of the employee union, and such acts cause the expulsion of the member from the union, then sometimes the employer will be held to account for an analogous cause, which is the union security clause. Okay, let's go to the next slide. Okay, so we're near the end of this lecture. So I just want to again impart the importance that the Supreme Court places on the employee. in that the cause for termination must be serious and grave malfeasance to justify the deprivation of means of livelihood. And this is because this is what the Constitution and the rest of the laws mandate, that every doubt be resolved in favor of labor. Okay, next slide, please. So this is just a summary table of the just and authorized causes. Again, the authorized cause termination of employment, we discussed that in a previous webinar. Please refer to the materials in Sprout's COVID resource website for further details on the authorized causes. But the just causes, please note that these are very strict. Ito lang yung pwede nyo gamiting ground for termination of employment. And you are required to observe the twin notice rule in all instances of just cause termination of employment. Okay, next slide, please. So this webinar series actually, I wanted to share that there was some particular thought processes that went into the preparation of this material as well. Because termination of employment in this period that we are in a pandemic, it feels wrong from a PR perspective, from a justice perspective. It feels unjust. It feels wrong. But I'd like to impart that discipline is just one lever to behavior, and commitment, positive tayo. It's a stronger motivator than fear. If your employees are afraid to commit wrongdoings because they're afraid of losing their jobs, will they be as effective as somebody who is committed to delivering the best work every time they enter the workplace? Whether it's at home or whether it's elsewhere or it's a company premises, mas magandang ang lever natin is the positive reinforcement, which is commitment to doing the best work of the employee, rather than the lever of discipline, and imposing fear on employees who are fearful of losing their sources of income. Now, so let's move to thinking about discipline positively and fomenting an environment of commitment to doing your best work rather than one that is merely compliance with rules and regulations. Okay. So with that, I think that's my last slide. Next slide, please. Okay, yes, that is my last slide. So again, I just want to wrap up by saying that just causes of termination of employment, you have to comply with the twin notice rule. And the grounds for termination of employment, they're very specific. There are elements to each ground. If you are uncertain about the element, or if you feel that there is a penalty lesser than termination that is possible to be imposed, and it is more just, more in line with what your objective is for imposing discipline, then do something lesser than termination. Because again, the courts will not look favorably to cases of termination of employment. The courts will look in favor of labor in cases of termination where there are doubts that may be resolved in favor of labor. Matatalo ang employer doon. Okay. So with that, I turn over the floor to Kyle.
Thank you, Attorney Lester. Yeah, thank you for that very informative talk. I know our attendees got a lot of good insight from our talk, so thank you again, Attorney. So can we go to the next slide, please? Okay, so I'd like to announce the third raffle keyword. Sana nakinig kayo sa presentation ni Attorney Lester. You got the second keyword there. But let me announce our third keyword. It's concealment. So to repeat that, it's concealment. So to give you a recap or to give a chance to everyone, so siguro yung iba na-miss nila yung ibang keywords. Here are the three keywords. Okay, so first we have labor. First is labor. Second is discipline. And the third is concealment. So again, the three keywords are labor, discipline, and concealment. So please join the raffle by first following our Facebook page and comment these three keywords on the post, pinned post, or the post containing this video. All right. So, but before we move to our Q&A portion, Allow us to show you a short clip so you'll know more about Sprout.
So you've got your processes, and your company is an oiled machine that runs pretty smoothly, but under the hood, you have problems. You've got managers desperate to know the status of their open positions, leave requests getting lost in a jumble of emails, SMS and forms, and employees complaining about payroll errors. You've thought about some expensive custom software that would be a pain to maintain, or swimming in all the features of SAP or Oracle, or maybe even outsourcing your payroll altogether. Why can't you find a local, intelligent, well-supported software that caters to your needs as a Philippine company? Well, guess what? Here at Sprout, we've developed a system that just works. One system with all the features you need and without all those that you don't. So what are you waiting for? Get over to sprout.ph and get your systems fixed today.
Okay, so I hope you enjoyed the video. It was a short clip about Sprout Solutions on how we can help you. Okay, let's proceed to our next portion of the event, which is our fireside chat. So kindly put out your questions and type in the chat box. But before we go to your questions, let me invite our panelists. Of course, I'd like to welcome back our our speaker for today, Attorney Lester Ople. So welcome po, Attorney ulit. And I'd also want to welcome our second panelist. She has more than 5 years of experience in human resources, overseeing recruitment, employee relations, and performance management in Sprout Solutions. So let's all welcome Ms. Shang Trinidad. So welcome po, Ms. Shang.
Hello.
Hello. So we also have our third and final panelist, which is Sir Geoffrey Ogang. Sir Geoffrey Ogang is Sprout's head of finance. So welcome, Sir Geoffrey. All right, so now that we have our panelists here, let's proceed to our questions. Siguro kanina pa lang ang dami ng question while Attorney Lester was presenting. But let me go to the first question. Let me just read it. So for the panelists, I'll read the questions twice so that it will be clear for everyone. Okay? So first question, given that we used biometrics in the office before COVID, now it's hard to have evidence of employees who under time or don't work on time. What are your tips in monitoring employees that don't comply with office work schedule? Now to repeat that, given that we use biometrics in the office before COVID, now it's hard for them to have evidence of employees who do under time or don't work on time. Now, what are your tips in monitoring employees that don't comply with office work schedule? So anyone in the panelists can start.
I would answer it in two fronts. No? So number one is you have to have a company policy on attendance. If you do not have a company policy on attendance, the hours of work, then you are in a pickle kasi hindi nyo talaga ma-enforce ang time in and time out correctly. And then number two would be, there would be a technology solution to that. And I would defer to Shang. Shang is our HR lead for Sprout, and Sprout, we believe in our own product. So maybe Shang, you can share about how Sprout uses Sprout.
All right. Hi. So we usually log in through two things. Like first is through our website, WebBondi, and second is through our mobile app. So that captures everything from your login to your logouts.
Yeah, so I think what we want to impress on our attendees is that there are two fronts. Number one, you have to have a policy documented. If you do not have a policy documented about your hours of work, then you have to document it and cascade it to your employees. Number two, you need to have a tool that helps you track and report time in and time out. And Sprout is, maybe Kyle, you can also talk about the rescue kit because that's something that we are really offering to our SME counterparts.
Yes, correct. So to dovetail on what Attorney Lester and Ms. Shang mentioned, we actually use different ways to time in and time out. So first, we use our mobile app. So it captures where you log in and log out the location, and we also use our web bundle. So there's actually flexibility when it comes to working from home, especially for the employees. So, and part of that, we launched Rescue Kit. This is something that we give companies for free, at least for 60 days, to be able to use our timekeeping tools, our attendance tools, and our payroll tools to help you with your work from home situations, especially now. So I will be sharing that further later. But to give you an idea, we're giving out Rescue Kit to help you with timekeeping, timing in and timing out. Yeah. So any more answers from our panelists? Okay, I think we're good. So let's proceed to our next question. Second question, for work from home employees, if one is not performing, can we extend or terminate an employee's probation during work from home? So to repeat that, for work from home employees, if one is not performing, can we extend or terminate an employee's probation during work from home?
There's a labor advisory that states the probation, or rather the period of the ECQ should not be counted during the probationary period of the employee. I have my reservations on that particular issuance as a lawyer because the law is very clear on what the probationary period is. But of course, we defer to the Department of Labor pending decision from the courts regarding the legality of that particular issuance. But maybe as a rule of thumb for the employers on this call, if you have an employee who's on probationary status, go back to what is required for probationary employment under Article 281, which is you have to have clearly documented parameters for the regularization of their employment. If you are unable to do that, then kahit gaano katagal ang probationary period nyo, mahihirapan kayong i-terminate yung tao. No? And again, what's the requirement for termination of a probationary employee? There has to be proof that the employee is not fit for regularization of employment. So if you do not have metrics, you will not have proof of the non-qualification of the person to be a regular employee. Oh, sorry, one more thing. If you are working from home, then that means you are performing, no? So baka for those employers who are working from home, then stick to the probationary period as stated in your employment contract or probationary policy. But if you have suspended, then refer to, I think it's Labor Advisory number 14. No? Let me do a quick check. Yan. Basta merong advisory si DOLE that states the ECQ period is excluded from counting of the probationary period. Okay.
Thank you, attorney. So can we move to the next question? All right. So the question is non-attendance ground for termination? Again, is non-attendance ground for termination?
Okay. Non-attendance would be, there's a separate process that we do for that. No? So what we do there is we call it a return to work process. When you do a return to work process, what you do is that allowed naman kasing umabsent ang employee subject to the rules of the leaves, no? Subject to utilization of the leaves. But if the employee is on continuous absence and there is no further explanation, we call that a case of AWOL, no? Absence without approved leave. In such cases, we recommend that you require them to return to work via letter addressed to their last registered address sent via the post office. So registered mail with return card. If the employee still refuses to return to work despite the sending of return to work notices, then again, subject the employee to due process requirements of the twin notice rule. And then that's the time that you will be able to make a decision on the AWOL case of the employee.
Okay, thank you, attorney. So can we proceed to the next question? All right.
Yep.
So For policies adjustments like 4-day work week or no work, no pay, how will we do this legally and how will it affect payroll? Yan. So for policies adjustments like 4-day work week or no work, no pay, how will we do this legally and how will it affect our payroll?
Let me go to the legal compliance first, no, and then I will defer to Joff and Shang for the payroll side. On the labor compliance front, please note that Labor Advisory 9. Sorry, let me go back further. There are two advisories issued by the Department of Labor, Labor Advisory number 4 and Labor Advisory number 9. Both advisories talk about the flexible work arrangements that employers may implement to be able to respond meaningfully to the pandemic, particularly to the ECQ. So if you are implementing a compressed work week or a reduced work days or any other arrangements allowable by the Department of Labor as stated in advisory number 9, then you have to comply with the COVID establishment report form. And you complete the data fields required in the establishment report form and submit it to the regional office of the Department of Labor, which has jurisdiction over your workplace. As to the payroll, I defer to Shang and Joff.
Yeah, so when it comes to the effect in, hold on. Yeah, I was just checking if I'm on mute. So when it comes to the questions with regards to payroll, so the 4-day work week is actually a reduction, of course, in the salary, and there are ways to do it. No, so for example, in Sprout payroll, you can first you may opt to adjust the salary base of the employee if you want the computation not to be as complicated as possible, or in some cases you can also treat it as a deduction, a deduction of a 1-day deduction from the pay of the employee. So yeah, so that's for Sprout payroll side. Shang, do you have anything to add to that?
So we just always remind our employees, since for example like the 4-day work week, not to log in and out on their chosen day off. For example, some of the employees choose Monday to Thursday, some choose Tuesday to Friday, so automatically the system deducts the 1 day that the employee did not log in or out. So again, it depends on your company policy when implementing the reduction of work hours or the 4-day work week.
Yeah, and you can set, for example, the employees working on from Monday to Thursday. You can set the Friday as a rest day. Yeah. So and then if an employee works on that rest day, then they can charge it as an compensatory time off, depending on the company policy, of course, when it comes to overtime. So yeah.
Okay, thank you everyone. Any more answers for that, or we can move to the next question?
Yep.
Okay.
Let's move to the
So,
next.
can we repurpose a talent legally? If so, how? For example, given that there is a suspension in an awards show, can we repurpose that assigned employee to another role? So I'll repeat that. Can we repurpose a talent legally? If so, how? For example, given that there is a suspension in an awards show, can we repurpose the assigned employee to another role?
Let me answer that from a legal lens, and then maybe from a talent management lens, maybe Shang can provide insights. No? So from a legal perspective, you have to allowed po ang reassignment, redeployment, reclassification of employees, provided you are doing so in good faith. Meaning, yung ginagawa nyo pong pag-change ng role, ng task, ng responsibilities ng employee, hindi pwedeng dahil lang sa gusto niyo siyang i-edge out, gusto niyo siyang i-manage out, you're setting him up to fail. Hindi po pwedeng yun yung maging grounds. No? So if you are in good faith, you are required due to the exigencies of the business to retool, repurpose, and reclassify employees. You are allowed to do so, provided you have good faith in doing so. And you also have to observe the concept called non-diminution of benefit. Meaning, if the employee is enjoying certain compensation or benefits commensurate with the role and as provided for in relevant company policy as well as in the employment contract,
you have to be very careful in retooling kasi if you're assigning that person to another role, baka magkaroon ka ng problema sa diminution of benefits. So you have to navigate that carefully. For example, you have a salesperson doing field sales. If that person doing field sales is a commission-based job, and then ilalagay niyo siya sa non-commission na eligible na role, then you have to navigate it in such a way that you still comply with non-diminution of benefits.
All right. So from an HR perspective, if you're going to assign someone to a new role, we have a document called the temporary job assignment, wherein ang mga important lang naman doon is the KPIs na kailangan niyang ma-attain during the temporary job assignment. The period, may it be like 1 month, 3 months, 6 months. So kailangan niya ma-meet yung KPIs na yon, the job description, kung sino yung bago niyang supervisor. So it's clear dapat yung documentation and should be confirmed, received, signed by the employee and the new supervisor. So I think the most important thing here is the communication.
Okay, thank you, panelists. So next question. If an employee has a recurring issue but undocumented, can we legally dismiss the employee on the first documented complaint? I'll repeat that now for everyone. If an employee has a recurring issue but it's undocumented, can we legally dismiss the employee on the first documented complaint?
My question there is, why did you let it happen for so long without documentation? No, discipline is this is a carrot and a stick approach. No, discipline is a stick, and you resort to the stick where the carrot no longer works. Now, if you are letting the employee proceed with a particular set of work attitudes, behaviors, and actions without a carrot or without a stick, then paano mo siya mako-course correct, no? So my take there is, on the legal side, whatever you do, comply ka lang sa twin notice requirements and invoke the correct just cause for termination of employment. You will be, whatever the circumstances are, it will be legal, provided you strictly comply with the particular elements for the ground applicable, and you comply with the twin notice rule and do the whole process with good faith, with the sole intent that you want to protect your business from an erring employee, not because you want to get rid of a person.
Yeah. For me, it's always the supervisor or manager's responsibility to document. So kung walang documentation, mahirap talaga.
Yeah, I agree with that. So also sharing my experience then in my past companies, no. So sometimes yung we fail to go to the disciplinary action part. So normally we just provide an NTE or notices like that, but that's not really a disciplinary action. So sometimes it actually ako din a victim of this, no. So I just ended up with issuing a notice to explain without having it documented to the HR. So at the end of the day, we were not able to push for the disciplinary action for that because it was not properly documented. So we just have to be careful, and we really need to know the process flow, the complete process flow. Yeah.
Dagdagan ko lang yung sinabi ni Joff, no, na parang managers should have an open line of communication with their human resources. Kasi what happens minsan is the managers fall into this particular trap na hindi, kaya ko tong balian ng sungay. Huwag nating isipin yun, no. What we should ideally do is we do our coaching activities, our mentoring activities, and then kapag hindi na gumagana yun, saka mag-reach out tayo in the soonest possible time to your human resources person, kasi your HR would be the proper resource to advise whether it's kaya pa yan ng intervention na positive or okay, let's proceed with a disciplinary process. So early communication with the human resources is always important.
Okay, thank you, panelists, for your answers. Can we proceed to the next question?
Yes.
Okay.
Before that pala, Kyle, may
Yes,
I
go ahead.
just, I want to pick a particular question on the chat box kasi nag-flag siya sa akin kanina. There's a question regarding how notices will be served during the ECQ, no? Whether email is applicable. I have a complex answer to this, and I would like to impress that the law and the jurisprudence is clear. Dalawa po yung option. It's personal service, meaning somebody hands over the paper to the employee, and then the employee receives or acknowledges it. Number two would be registered mail via return with return card. And bakit siya may return card rather than regular post, or bakit hindi private courier? Kasi there are evidentiary rules at play here, and registered mail with return card is the best option given the circumstances. Now, in the ECQ, is it possible to do so? I'm not exactly sure if the post offices are open, but if they are, then I think the options should still be via regular mail or registered mail with return card, because your policy may not be explicit that email service is allowed. Other option is you have to have a policy of using software or electronic means of serving your notices to employees. So having an email system, having an HR system that can track documentation will become important, like Sprout. So si Sprout kasi we have HRIS, so all of our personal actions are on our software, and then we have an email system that can track. We have a system that can track whether an employee received and acknowledges correspondence via software. So allowed si Sprout to do that because two things: our policy can do it, accommodates for it, and then number two, our technology allows for it. So if you do not have the policy and the technology for it, do not serve via email. Do it via the personal service or via registered mail with return card.
Okay. Thank you, attorney. I think that was a recurring question in the chat box. No? Medyo
Oh, okay. Hindi ko napansin na recurring siya. Pero nakita ko ilan silang nagtanong.
Yeah. Thank you for addressing that. So,
Thanks.
panelists and attendees, we have the last question. So, ito po yung last question. This is about SBWS, no? When an employee is retrenched and the effective date is 2020 May 15, last day ng 30 days notice, but he or she was able to receive SBWS last 2020 May 5, is the company liable to refund the subsidy amount? Is there a rule for SSS or a legal implication besides the refund? Yes, go ahead.
Yeah, this is a very sticky topic. Why? Because I am aware of so many companies who have filed for an SBWS. Ano yan eh, continuum of time kasi yan eh. When SBWS application was opened, companies who are pre-qualified applied, and then in the middle of it, somebody would have filed, resignation in between or slightly before it, and then it's highly probable that there are so many companies who experience that. And my recommendation is right now the rules are silent regarding how to treat cases of resignation. Kasi ang pangit din naman kung ikaw yung HR, syempre iisipin mo yung welfare ng employees ng company, no? So even if may resignation na, dahil active employee pa siya as of that date, then dapat ilagay siya doon, di ba? But how I would recommend it is be candid with the employee, communicate that these are the rules for eligibility, and definitely hindi pa naman kayo nagpa-process ng final pay, no? So gawan nyo na ng authority to deduct yung employee kasi kayo ang employer ang babawian ng SBWS benefit, hindi si employee.
Okay, thank you, Attorney Lester. For that last question, do we have another answer from the panelists?
For HR, yeah, I agree with Attorney Lester. Just communicate with the employee. So what, if ever, what we're gonna do is talk to our employees and make sure na may documentation, which is yung authority to deduct, signed by the employee. So yun.
Thank you.
Yeah, actually, to add to that, no, the problem with that, ang magiging problem na lang doon is what if the final pay cannot cover for the SBWS? So that's the that's a risk that the company has to take. Yeah, you just
Dagdagan
have
ko pala yan, no?
to go.
Yeah, may isa pa pala, no? Please also note that the Department of Labor has mandated a 30-day processing time for final pay. So, ang dami natin ngayong minamanage na timelines. May ECQ pa or GCQ or MECQ, depende kung nasan ka as an employer. And then yung mga empleyado ba natin, taga saan ba sila? Galing ba sila sa lugar na GCQ na? Papunta silang MECQ? Yung industriya ba natin covered na dun sa mga ano, no? And, the reason why we have this webinar is that the government issuances have been so dynamic, and we feel that it's our responsibility as good corporate citizens, and we want to share what Sprout has inside, and that's why we have this particular webinar series implemented. And also yung rescue kit, very handhold, ang dami pong handholding na nagaganap sa implementation yan. So we are very proud of the rescue kit. And we're doing this not because it makes business sense for us. It's because our company, and thankfully our CEO also, they want to share and help share the burden with the rest of the industry. That's why we have this in place. So please continue attending Sprout activities on Facebook and on Zoom, because this is where we try to make sense of the government issuances pertaining to the ECQ and other legal requirements.
Yeah, thank you, Attorney Lester. So our time is up for this panel session. I want to thank our panelists, Attorney and Sir Geoff. Thank you for your informative inputs. I believe our audience members were very informed of your answers. So thank you for that. Thank you, everyone. Maraming salamat. All right, so on to our next slide. We were mentioning about rescue kit several times during the session. I just want to formally introduce this and inform everyone that we are actually offering the rescue kit for all your HR help for free for 60 days. So this includes an digital activation process, and then you'll have an access to a BCP expert who will help you with your BCP plans and processes. And then we also have free Sprout HR. So it will include yung basic timekeeping policies and to keep your staff going. And included, of course, is yung Sprout payroll. So it will help you with your payroll runs and your computations. And of course, add on to that, we have different tools that we can offer with the rescue kit, which includes yung Sprout loans or Sprout Instacash. Yeah, so ito yung parang advance for your employees. This will help a lot of your employees actually. And then next, we have yung mobile app and web Bondi. These are our timekeeping tools. Especially if you're working from home, your company is working from home, this will help you track your timekeeping, time in and time out of your employees. And of course, you'll have access to our technical consultants for questions and concerns. So if you are interested and if you want to sign up for the rescue kit, again, this is free for 60 days. Can we go to the next slide, please? Free for 60 days, you may sign up on the link provided on the screen. So just go to that link and then sign up there. And then next, you can also contact me. You can see my details. Next slide, please. You can see my details on the screen. So there's my email and my phone number. So if you're interested and if you need it, we're happy to help you to provide you the rescue kit for 60 days with all the inclusions that I provided a while ago. So again, the sign up is until May 31. So please sign up and feel free to contact us. All right, so next slide. Okay, so I think this is the time that everyone is, the moment that everyone's been waiting for. I'd like to announce the 4 raffle winners. Yan. Okay, so let me just read the names of the winners. Yeah. So please take note. If I mentioned your name, kindly send in your email address in the Zoom chat box or in Facebook so that we can send the GC codes to your email. Okay, so here are the winners. First, we have Jimson Mendoza. So congrats. Again, that's Jimson Mendoza. Congratulations to you. Second winner, we have Bea Samonte. Yan. Ms. Bea Samonte, congratulations. Please send in your email address to the Zoom chat box or in Facebook. And then next, we have Nestor Lim. We have Nestor Lim. Congratulations, Nestor Lim. And then fourth and last winner, we have June Benedict. So June Benedict, congratulations. And again, congratulations to all the winners of the raffle. And please type in your email address to the chat box. All right. So for those who attended this webinar, we can also send you e-certificates. Yeah. So here is the instruction to get them. So please email a request to info@sprout.ph. It's flashed on the screen. And kindly indicate your full name, your company name, and your position in that company. So again, if you want an e-certificate of attending this webinar, kindly send in a request through the email flash, which is info@sprout.ph. All right. And please don't forget to follow our social media pages and use #OB with Sprout to be updated on our events. So again, thank you, panelists. Thank you to our speaker for being here and answering the questions and giving informative insights to our attendees. And thank you, attendees, for being here in our webinar. We want to see you on our next webinar. And please don't forget to sign up to our free rescue kit. So thank you, everyone, for attending. Hope you are safe and take care.